issue, it's a national issue. If there is anything they would desire, we recommend they cause a referendum.
Opposition to the Protection Sovereignty Bill continues to grow, with civil society organizations describing it as oppressive and selectively applied. The Civil Advisory Hub has urged Parliament to carefully scrutinize the bill before passing it, warning that failure to do so could lead to serious future repercussion. Clause 20 of the bill requires mandatory registration with the Department of Peace and Security, including 2-year certification, mental health checks for directors of the CSOs and NGOs, and allows warrantless inspection of organizational premises and records, including personal data.
A law developed like Uganda that sometimes survives on humanitarian assistance to put cumbersome processes of clearing of assistance, mainly for the humanitarian organization. I think this is disastrous. It's not necessary. And if the country wanted anyway to mitigate any sovereign interference, we have already a batch of existing laws.
Bill, while it purports to protect sovereignty, it undermines sovereignty and projects what we will call hollow sovereignty, because it empties sovereignty. Because one, it undermines the capacity of citizens to engage in public affairs. That's what it does, because it has put so many bottlenecks in the details of that law that makes it difficult for citizens and citizen organizations.
Clause 13 criminalizes the publication of information or participation in activities deemed to weaken or damage the country's economic system, which critics say could be broadly interpreted and potentially misused. Analyzing the bill, legal experts from Onyango and company advocates urge that although it outlines penalties for offenses, its wording remains vague and open to abuse.
The bill has clauses and definitions that are problematic, overly broad, and could pose a significant impact, and a negative one to CSOs, or civil society organizations, and also to the citizens generally. Some of these clauses give the state a leeway to think of what is bad by the law. Yeah? It does not specifically indicate what activity is actually bad. For example, disruptive activities. The clause on disruptive activities includes fronting interests of a foreigner, but it does not go in depth. And yet, in many things we do, you may end up being linked to fronting interests of a foreigner.
They further warn that enacting the bill is a duplication of existing laws already provided for under the Constitution, as well as legislations such as the NGO Act, Cap 109, the Penal Code Act, Cap 128, and the Anti-Money Laundering Act, Cap 118. Mutonyi Hilda and Mike Bakablindi, UBC.